All right. Thank you. Thank you, everyone, for joining our webinar today, um, deciding to come and spend time with us. We really appreciate it. We hope that what we talk about will be useful for you, that you could use it. Um, Let me not delay in introducing our guest today. We have John Henson. He is an attorney and he founded Henson Legal last year in May, your own law firm, right?
Yes, yes,
All right. And then you were general counsel at consumeraffairs.com.
yes,
And then you were also general counsel and VP of compliance at Lending Tree.
yep. Yeah,
And
so
you,
I've unfortunately or unfortunately, Tammy, I've been in this a while. So, yeah,
fortunately,
yes, fortunately.
yeah. And I know you talked about you had shared with me, that you've been guiding household name brands
Yeah,
um from through marketing, complex marketing regulations. And right now, if you want to talk about it, go ahead. But I know you shared you're helping lead buyers, lead generators, AI
yeah,
voice product builders. Please
yeah. So
share.
I have my clients basically fall into two buckets, right? So we have the lead generation bucket, lead buyers, lead sellers, and then the other bucket is essentially platforms, mostly around AI voice, that are being used to contact customers. And there's a lot of overlap there between TCPA regulations for those lead buyers and sellers, and then the AI voice products and CRM products that they're using to contact those customers. So
Mhm.
that has been my I help clients in those two buckets, but in various verticals: insurance, mortgage, real estate, pest control, vet clinics, all across the board. So
Everybody needs it.
that's right. I mean, if you're calling customers, this is the kind of thing that you really want to be aware of and understand how it affects you.
Yeah. All right. Well, thank you for coming on. My name is Tammy Glover Fowler. I am Legal and Compliance Director for Contact Center Compliance. And we have a host of cloud-based software products to help you comply with TCPA, TSR, and state regulations. We have your Do Not Call Scrub, Reassign Numbers, Litigator Scrub. We also have a wonderful compliance guide. It's a tool that holds all of your federal TCPA regulations, your state regulation, and it breaks it down for you. You can look up your calling times, your consent disclosures, things like that. And then we also offer caller ID and branding remediation for your phone calls. So that's what we do over here. And today we're going to talk with John about an interesting topic. Um, our title today is a look at the totality of circumstances, determining who is liable for TCPA violations. We'll look at dialer technology versus telemarketer caller, who holds liability for calls. So, John, do we want to explain what of totality of circumstances are at the beginning, or do we want to save it for the end or and add, talk about how it adds up? Which way do you want to do that?
Yeah, so we'll talk about it. So in this
Okay.
instance, right, totality of the circumstances relates to how courts look at who is liable for the calls, right? And TCPA says the seller is liable for the calls, and they say that the definition of seller is whoever initiates the call, and there's really not a good regulatory definition of initiate, so that comes from the courts, and the courts look at the totality of the circumstances of what were the actions that took place for the calls to start, who pushed the button for the calls to start, what sort of agreement do the parties have. It's really just boils down to vicarious liability and how we assign that liability to other parties, right? So what's interesting about vicarious liability in a TCPA context is that there's lots of different, it really affects everybody, right? So um, I said I have two buckets. I have lead generators and I have the platforms.
Mm-hmm.
There is case law out there that says the platform is responsible. There's case law out there that has, for certain fact patterns that says the lead generator is responsible, um, or the lead buyer, right? Whether
Mm-hmm.
the end user. So we'll use mortgage, right? So maybe it's Wells Fargo Mortgage. Maybe they're responsible for it. Well, maybe they're not. Maybe it's a third party call center, right? So that's what that means when we say the totality of the circumstances. The courts look at the fact pattern and look to see who was actually so involved in the process that they initiated the call, right? And if it's not the end user, so Wells Fargo in our example, has Wells Fargo done anything to make them responsible for it?
Mm-hmm.
And how that happens is a couple of different ways, right? So there's a theory of that there's three ways in vicarious liability that a court can find a party vicariously liable for the actions of a different party.
Okay.
There is apparent authority, right? So Tammy calls consumer and says, "Hey, this is Tammy. I'm calling on behalf of John Henson Mortgage. Love to get you a mortgage. Would you like to talk to somebody there?" Right? A reasonable person would assume Tammy has the ability to do that, right? Because she's holding herself out. She's calling on my behalf.
Mm-hmm.
That's apparent authority. Actual authority is, Tammy, I need you to go call a bunch of people, send me a bunch of mortgage leads, right? So that is apparent authority. I've told you to go do it on my behalf. And the third one that's very interesting is ratification, right? So Tammy
Yeah.
goes off on her own. She starts calling people. "Hey, would you like to talk to John Henson Mortgage?" Great. And you send it to me. And I engage with the customer and I take their information and try to sell them a mortgage, right? By me accepting the customer and continuing to work that lead, that is a ratification of your actions, right? So
Mm-hmm.
obviously those are very simple examples, but that's kind of the three concepts here. And you and I were talking about earlier, we've seen a couple of cases lately that have really changed that vicarious liability dynamic and try to place it out among other companies. So
Mm.
there was a case, I think it was at the beginning of February, not important, earlier this year. The company, it was a mortgage company, right? It was,
Mm-hmm.
I think, Nation One Mortgage. They had an AI voice dialer that was calling customers without consent, allegedly. And the consumer wasn't really sure who was calling. So they, went down the process with the caller and ended up with talking to a loan officer. Let's call him Bob at Nation Mortgage. They talked to Bob. Bob said, "Hey, I'm Bob at Nation Mortgage. Love to get you a mortgage." They talk for a little bit. Same day that he gets an email from Bob at Nation Mortgage that says, "Hey, great talking to you today." And the claim is, look, we assume that Nation Mortgage used this AI bot to call, this AI voice agent to call. They didn't have prior express written consent, which is required for AI voice
Mm.
doing marketing, right?
Mm-hmm.
And because that AI voice bot called me, they sent me to Nation One Mortgage, and Nation One Mortgage emailed me from a Nation One Mortgage account. It's pretty clear that even if they didn't have actual authority, they definitely ratified the actions of whoever
Yeah.
this telemarketer was using it on their behalf, right? So
Right.
we can find it that way. So that's one interesting case. The other interesting case was filed at the end of last year against telemarketer Twilio and OpenAI. And the reason that one is interesting is because this is what we'll talk about, I'm sure, some more about the platform liability, right?
Mm-hmm.
Saying that OpenAI is liable because OpenAI was doing these activities and marketing these activities for cold calls. I can't remember the exact wording, but there was some marketing language on OpenAI's website that says, if you use this API, you'll be able to do hundreds of cold calls, right, at a time. And that was enough for the claim from OpenAI to at least bring them in the lawsuit. That is obviously ongoing, but that is out there, right? So that is how this apparent liability works to bring in additional parties, whether it's in addition to the person who's trying to sell you something, that end buyer, or in addition to the telemarketer at that time, how you can bring in additional parties and lawsuits.
Yeah, I mean, let's look at it from just the beginning of everything. Using the two examples with the cases that you just talked about, let's start from the beginning and look at who initiates the call. Who's initiating a call? Why are they making calls?
Yep.
We could go old school, like you actually have a company that's making calls by employees, or they hire a third-party vendor to make calls, or a company is accepting a lead and then they make the call. So let's talk about how a call actually gets initiated.
Yeah, that's a great question, right? So courts have said that whoever is taking enough steps necessary that the calls get placed, right? That they have to be an actual cause of the calls going out, right? And what that means is, are you doing enough steps that those calls wouldn't happen but for you being involved, right? And we see this a lot in the platform liability space where TCPA lawsuits try to bring platforms in. And I always tell people that everything in life is a spectrum, right? And if you're a platform and you're a texting platform, right? And you want to help your clients be able to text consumers, but you don't want to be involved in any platform liability, right? So on one side, we have turnkey. I like to explain it as like, here's your login, enjoy the platform.
Yes.
You send me your monthly bill, right? On
Right.
the other side is white glove concierge. Let me set up your account. Let me set up your campaigns. Let me tell you the best times to do it. Let me tell you the best things to say. Let me chop up your client base into pieces so we know that we're sending the right people the right things at the right time, right? That's the other side. The closer you get to this white glove treatment, the riskier it is from a platform liability standpoint, right? Because the court's going to look again at the totality of the circumstances and say, you're so involved in this transaction that these calls wouldn't have happened without you. There was a case last year where Woosender was named, and Woosender tried to get out, and the court said that they had not provided enough information to say that they weren't so involved in it that they couldn't be held liable, and the courts, they didn't get their motion dismissed. So you really have to understand, and it's everything from how your UX is in your platform, right? How the platform works, how we're marketing the platform. What does your sales team say? What does your customer success team do? You have to think through this whole situation to make sure that you're not too close to this line, right? And that you're somewhere in this range over here, so you don't get involved in that platform liability.
Right. And even if you don't go, let's say you're on the white glove side of things and you do everything, all this help and assist, but you still don't press send, there's still some totality there that'll show that you were just so involved in this process,
right?
That there still may be some liability for even the white glove treatment.
Right. Absolutely. And it's anytime that we're in a circumstance where it's not black letter law, right? And that the court's going to look at, again, the totality of all the facts and the circumstances and everything, right? It's just becomes dangerous to stack things up on one side, right? Without corresponding stack on the other side. And that's where I think people get messed up, right? And in some of these cases, right, like there's contractual obligations that says, hey, we're not involved in this, right? And you can say that, and therefore, court, this contract says we're not involved in this at all. But your actions
Mm-hmm.
are making you involved in it, right? So you've got to
Right.
balance, you've got to protect yourself from both of those instances.
Right. So we're demonstrating initiating a call, and we kind of dipped into helping to train on using the platform, how much involvement you have in the platform. Um, let's just talk about some different types of calls,
Mhm.
while we're going down the line. Like I said earlier, you could have a direct company having its employees pick up a phone, make some calls. You could have a big organization that has a bucket of consumers that they have a relationship with, an established business relationship. They load it to a dialer, make the calls, or you could have a company that's generating leads, buying leads, and they're loading it to a dialer to make calls. So we have different types of companies and organizations making calls, and then how are they making the calls? How are they using a dialer to make call? Can we talk about that?
Yeah, and I think the important thing here is probably I think you're right. We should probably should have taken a step back. This vicarious liability only applies when you've done something incorrectly, right? So
Mhm.
if you're getting consent for your calls, right? If you've got the proper EBRs and that you're not violating TCPA, this doesn't come into play. It's only on those allegations of TCPA violations that these come into play, right?
Mhm.
So, if we're using AI voice, automatic dialers, ringless voicemails, those regulated technologies, if you have prior express consent for informational calls or prior express written consent for marketing calls, right? You're good, right?
Mhm.
On the DNC side of the house, as long as you've got consent or have an established business relationship with these customers, a valid one, and nobody has revoked their consent, right? You've gone through all your checks and balances. Again, you're good. It's when we're outside of those two areas that when there's an issue and if you get sued, we want to say, hey, who's liable for these calls? Like who's
Yes.
responsible for these TCPA violations? And I think that's very important to clarify. So thank you for saying that. The clarification is this only happens when you are violating TCPA.
Mhm. Exactly. And so under the risk of violation,
Mhm.
let's say you're facing that, and regulators need to come in and now look at your activity to see who's liable. So let's talk about the type of reactive versus non-reactive activity
Mhm.
in terms of using a dialer and
Yeah.
initiating calls. How
Yeah.
can we make that distinction?
Yeah. So I think you want to look at again, how are you calling people is always step one. Well, step
Yeah,
one is do you have consent? Right.
right.
What does the consent say? Because whatever the consent says will then dictate how you can call those customers, right? So if it says, I want you to call me at this number, period. Okay. Okay. That's not consent for marketing calls. So that's consent for informational calls. Okay. And therefore,
Mm-hmm.
if we were going to use an auto dialer, right, we could, or AI voice or ringless voicemail, any regulated technology, then we would have to wait and just use those calls for informational only.
Right.
Now, if the language says, hey, use this number for marketing purposes, okay, that consumer could get marketing calls. Okay, great. We'll agree on that. Could they get the language, excuse me, says, call me on this number for marketing. Okay, great. Does it mean you can text the customer? Maybe not. Does it says you can use a auto dialer or AI? Maybe not, right? So that's why it's super important. Step one, what does the consent language say?
Mm-hmm.
Now that we know what it says, we know how we can put those
Contact you.
numbers in those contact buckets, right? So we're going to call them using an auto dialer because we have permission, or we don't have permission and we have third-party telemarketer calling them with autodialers. Okay. Now,
Mhm.
now we've brought vicarious liability into play, right? Because I don't know, telemarketer number one starts using an autodialer and blasting you, right? Transfers those calls. The reason vicarious liability exists and is important for TCPA purposes is, again, if I'm Henson Mortgage and I've got a third party telemarketer out there, you know, breaking TCPA laws, and they're doing it on my behalf, maybe I'm the
Mhm.
deeper pocket, right? And the company, the consumer wants to sue me because these people are acting on my behalf. So that's kind of
Mhm.
how that works. And when you think about who is controlling that calling activity, right? Is it the third party or is it the bank or the mortgage company in our example? So I think that's an
Mhm.
important distinction too to think through is how is that being handled? And that's what
Right.
vicarious liability, and we have to look at the different circumstances there.
Right. So we need to take note of the manual dial, the automated dialer, the
Yep.
AI voice. Make sure you understand which level of consent you need to send those.
Yep.
Okay. And most likely, people are going to want to automate,
Yep.
and like we said earlier, AI calls, which are pre-recorded calls, those you can do as long as you have the proper consent.
Yes.
So now we're going to place these on a dialer. Most people are going to place these on an automated dialer.
Yep.
So now, for the sake of liability, when you place those calls on a dialer, what is reactive versus non-reactive activity on a dialer in terms of who would be liable for the actions?
Yeah, no, that's a great question. I think the way to think this through is like, again, everything's a spectrum, right? So on one side, you've got, hey, this is our call cadence. We make 2 calls the first day, 1 call the second day, 1 call day 5, 1 call day 10, right? And
Mm-hmm.
nothing else matters. Doesn't matter. By God, hell or high water, that's the cadence, right? The other side is, and we're seeing this a lot in the AI space, of like, oh, we know enough about these customers, we know enough about the behavior of these customers that we can change these back and forth. And uh, you know, this these consumers may get 3 calls day one, 2 calls day two, 3 calls day three, right? But this same bucket in the same campaign, because of the AI features, may go 3, 2, 1, right? So
Mm-hmm.
that that's going to put you closer to that white glove concierge. So what else are you doing as a platform to making sure that you're not going to be held liable for these calls, right? And
Mm-hmm.
one of those things is you better have consent, or your customers using the platform better have consent to make those calls. And this becomes really important for the AI platforms because the FCC has been very clear the use of AI voice is going to trigger the regulated technology requirements for pre-recorded or artificial voice. So it doesn't matter what the call says in an AI voice. You're gonna have to have some level of consent.
Mm-hmm.
And you know, I have a couple of customers in the automotive space, right? And we have this conversation. Well, we're just going to use this to tell people their cars are ready from the service center. Okay, that's great. That's an informational call. Tammy, your car's ready to pick up. We all like that.
But,
That's an
but,
informational call, right? Um,
yes,
but because you're using the AI voice, you've got to have at least prior express consent, right?
yeah,
And that's where I think a lot of people are thinking it through. Um, and I want to say, and I've said this before, and you've heard me say this before. The key to understanding this is uh, everybody talks about consent, 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 and that's super important. And it's like the gating issue to all TCPA issues, right? But
mm-hmm.
the other important part of this is this just shows you how TCPA is as much as a third party vendor management statute as it is anything else. Because unless you are driving your own traffic, calling your own leads, doing everything solo vertical in-house, right? You've got a third party helping you somewhere, and you want to make sure that you're not responsible for their screw ups, right? So you have to understand what they're doing on your behalf, right? Whether that's a dialer, whether that's a marketing partner, whether that's a third party telemarketer, right? You've got to understand what they're doing on your behalf.
Mhm. Yeah. When I read your newsletter about this and you broke this down, I just think this is a topic that is just so missed. It's missed by so many people. It's not talked about enough. Um, and one interesting thing about it is, when you're a company making outbound sales calls using a platform, and if the platform is so involved that it begins to take on some of the liability, that platform now becomes a telemarketer.
Mm-hmm.
We forget this, that your platform could actually become a telemarketer if they get so involved. And if they hit send in the end, now they're a telemarketer, and now they're subject to telemarketing registrations and ADAD registrations, which we don't talk about a lot in the
Yeah.
different states. So not only do you want your platform to just remain a tool, you don't want to be classified as a telemarketer because that's not the business that you're in.
Right. And if they are, right, like if they're going out there and they're going above and beyond, right, you sure better make sure you know what they're doing.
Yeah.
Because as we were talking about the ratification problem, right? Like if they're going out and going nuts and doing all this stuff that you don't want them to do, but you're happy to take their leads and convert those customers, then a court's going to say, hey, like you either knew or should have known, and therefore you're going to be just as liable as they are, if not more so, right? So
Mhm.
um, I think it's very important to, again, definitely understand what your third parties are doing, even as something as um, innocuous as a platform, right? Because you think, oh, I'm just going to sign up for this, they'll send some text out, it'll be fine, right?
Mhm.
Really got to think through what they're actually doing.
Mhm. And more on your reactive and non-reactive behavior that you talked about in your newsletter. So reactive is like the customer completely controls the activity. The dollar platform is just a tool, not a participant, not an initiator. There's nothing happening.
Yeah,
But if you're on the opposite side, the dialer provider is providing some kind of control. They are playing an active role, and they would be considered an initiator. This goes back to who's initiating the call.
yeah. I think that, like, if you think it is um, I'm not going to say that you have to understand who's pushing the button, right?
Mhm.
You should understand who's pushing the button, right? But like, if you think it's a set it and forget it like situation of like, I'm just going to upload all these into this platform and we'll take them as they come, right? Um, and you don't have somebody monitoring that and seeing watching what's happening in the dialer. How many dials are they making? How many,
Abandon rates,
yeah, all
you
that
know.
stuff, right? Like at that point, you're pushing all that liability. You're taking a risk that dialer is doing something you don't know about, and they're still going to come back to you because you're in trouble for it, right? Because you weren't actively monitoring it, right? Again,
Mhm.
you're not actively monitoring it, and you're still reaping the benefits of it because you're still taking those calls and those leads, right?
Mhm. Yeah, and that's an excellent point. So you can't be hands off.
Right.
If you're the company that's taking your leads or your business relationship consumers and loading them to the dialer, even though you've been trained and your settings have been established up front, you still have to go in there and monitor it. You still have to go in there and request reports on what's been happening. You want to manage those abandon rates.
Yeah.
You want to
And
make sure the time zones are correct and things like that.
yeah, and if you have a platform, like you need to think about it from the opposite way, right? Of like, unless you want to take responsibility for everything that goes on, You really need to think through like how your clients are using your dialer, right? Or your platform.
Mm-hmm.
Uh, am I a pure concierge? Which is, again, that's fine. It's perfectly fine. But it's a different risk profile than just sending somebody a login and saying, good luck, right?
Mm-hmm.
So you just have to understand those risks.
Yeah. Both sides should perform at their maximum level for one another,
Yeah, exactly. And I
you
think that
know.
like where both sides get in trouble, what I see is they don't understand where we are on the spectrum, right? And
Mm,
we don't understand how you can, sorry about my camera, I don't know what's going on
it's okay.
there. The how we can adjust, to the preferred risk position of each party, right?
Mm-hmm.
Because you have some people who are like, no, I want full white glove. You have lead buyers who say, no, I want full white glove. I want to put all the risk onto the platform. And you have platforms who are like, we want to be full glove. We will take all the risk, right? I
Mm-hmm.
have clients who do that, right? I have other clients who are like, I don't want any risk. I want them to click that they've got consent to call everybody before any dial is made, before any file is uploaded, before I even look at it,
Right.
they even sign into the platform, right? And again, that's their risk profile. Their clients are happy taking that risk, right?
Mm-hmm.
So that works out. There's a lot of fish in the ocean, and you can find somebody who will match with your risk level.
Yeah, your risk appetite.
Yeah.
That's right. Yeah. So, all of that brings us to, we talk about each side performing at its best for one another, how much liability you want to take on for one another, where's your confidence level. It comes down to knowing your customer. Each of you should know your customer. Each of you should vet one another.
Yeah. Yeah. And especially on the platform side, right? Because we're seeing the FCC become very aggressive with the robocall mitigation database and enforcing their rules. Last week we had two rulings come down. One is actually very interesting and somewhat, you and I didn't talk about this, but it's somewhat applicable here, right? So we had a company that had a bunch of clients. They had this client that had been a client since 2017, I think.
Okay.
They didn't make any calls until they'd stopped making calls in 2017 or maybe 2018, and then picked up again in 2025, right? And in 2025, they were live on the network for 3 days, sent thousands of calls, and raised several traceback requests,
Bam. Yeah.
right? And so like
Yeah.
lots of problems for the carrier, lots in the network. And now the carrier, to their credit, went in, cut them off, did a bunch of diligence, saw that they shouldn't be doing what they were doing, and cut them off. But the FCC said, here's the problem. You did diligence in 2017 when they came on the network, but you never looked at them again.
Oh,
Since they already had the connection, they were able to go in and do all these violations. And one of the violations for this group was that the caller that had been dormant, right, is they didn't have a robocall mitigation plan, which was required since they were a foreign caller. And that's very FCC, very technical, but it's a great case in point of like understanding if you're the platform or you're the network,
right.
understanding who your customers are, what are they doing on your platform, right? Uh, doing at some level of diligence of what they're going to be doing, because if you want to lose your ability to access the broader networks, right?
Mm,
You've got to do a good job of knowing who's going to be using your platform to go after the broader networks. And I think that's a
mm-hmm.
case in point um, the
KYC.
of the
Yeah.
KYC, right? Of like understanding who your customers are, how are they using your services. And the flip side of that is if you're a lead buyer, it's not true KYC, although it is if you're a bank, right? Or a financial institution. is that you have to understand, like, these people are getting this information, and what are they doing with this information? What sort of consent are they getting? You have to understand who you're getting into business with, right? And so I think
Mhm.
that's a great example of that.
And ongoing would have spotted that
Yes.
client who they looked at in 2017 and not again until 2025.
Yeah. Yeah. I mean, even just those annual certifications of like, hey, are you still located in wherever you are? Are you this is this the right email address? I see you don't have why are you not in the RMD? Right. So
Right,
those kind of things you've got to be able to do.
right. So things like under KYC, definitely identify the customer, the type of calls that they're making.
Yep.
You want to try and verify that,
Yeah.
you
And not
know?
only that, but like also call volume is super important, right?
Yeah,
Like if you have a client, well, let's just say they do 1,000 calls a day, and then you look over now they're doing 10,000 calls a day. Like something's happened there.
yeah,
What are they doing? And I'm not saying you should cut them off, but I'm saying you should be asking some questions, right? Um,
yeah.
especially if you're used to dealing with smaller call volumes, right? You maybe have a
Mm-hmm.
lot of clients that deal smaller call volumes. We see that a lot of bad actors will go to a platform or a network and they'll do 200 calls a day, right? For 60 days. And then it's like, oh, 10,000, right? Like and
Mm-hmm.
that gets the regulator's attention for sure.
Yeah. And it's in those cases where if you're watchful, that might trigger the platform dialer to say, hey, we want to test your consent.
Yep. Yep.
Send us some pieces of your consent so that we can understand the spike in these calls and the
Yes.
number of consumers that you're contacting all of a sudden,
Yeah.
you
Yep.
know.
I noticed we had
Um,
two questions, by the way, and I think they're good questions. So
let's go.
I want to address those real quick. So
All right.
first one is if you have a recording of the call consent, is that sufficient for prior express written consent? No. Oral consent is not prior express written consent in and of itself, right? So the consumer has to be given a written disclosure and they have to agree to that written disclosure. Are there ways to do it over the phone with maybe text or a follow-up text or email? Potentially, yes. But just saying, hey, can I call you back at this number with marketing messages? And the customer says, or the consumer says, yes, that is not going to be sufficient. Second, if you get express written consent, is it valid until revoked? Yes. Does it supersede national do not call? That's a great question. And the reason that's a good question is because, kind of like we talked about at the very beginning, there's two buckets of the TCPA. There is regulated technology, which is the autodialers, AI voice, pre-recorded voice, those technologies. That is where we get the express written consent language.
Mm-hmm.
Do not call bucket of TCPA regulations. Um, it regulates telephone solicitations. Telephone solicitations are marketing, phone calls, and there are a few exemptions out of that. One of them is the established business relationship, which we've discussed a little. And the other one is prior express invitation or permission, which is a fancy way to say consent. And so in that case, your express written consent to call me is going to work for regulated technology, and it would get you out of that DNC bucket too. So again, those are very high level, very broad. There is some devil in the details there, but to answer those questions now.
And keep in mind that, yeah, that a consumer can revoke their consent at any
Yes.
time, and you should accept that through a reasonable means.
Yes.
All right. Do you want to take this next one? I wanted to give some pointers on know your customer. We can do whatever you would like, John.
Yeah, let's do this one real quick.
Okay.
The best approach for an original creditor conducting all activities in-house to remediate a batch of its own consumer lending customers identified as lacking prior express written consent for marketing communications. Okay, we'll stop there. actually, I'm not going to stop there because you do a really good job. Whoever this is did a really good job clarifying the second part. So specifically, would it minimize regulatory risk to capture this consent via an opt-in gate during their next app login? That is doable. Script a request into their next account servicing, non-collections call inbound or outbound. That's not that the call scripting is not going to be enough to get you prior express written consent. Or execute a targeted manual dialing campaign dedicated to securing their authorization. You can have the same problem there. So of those three options, I've had clients in the past do the consent to opt in on the login. I think that works nicely. There's ways to do it.
From that, yeah.
Yeah, there's ways to do that. I've also had clients do email blast, right? And do an email blast, get those consumers back into the funnel. I kind of like the email blast because it will
you can capture
it'll
that.
also cut out people who don't care about you anymore, not to be rude, right? But like, you know what I mean? Like there's a certain amount of consumers that will engage in your emails. Those are good consumers for you. So let's get them back in and get their marketing consent as well, right? So I think either that some sort of email drop or that login gate, I think is a good way to do that. Good questions.
All right.
Yeah,
Awesome.
so let's go. We can go back into KYC. Sorry.
Oh, no, that's perfectly fine. We'll watch for some more. Just let me know. Yeah, I just wanted to let our audience know some things that you can do for KYC is, definitely go out and make sure the company is actually in business, that they're registered with the Secretary of State as a business. If they're not a known name, like I won't name any names, but you want to make sure that they are actually in business. You want to check for TCPA, TSR violations. You may want to take a look at their content, their script review, and also just go in there and take a look and see if they're attaching the caller ID that belongs to the company that's actually making the phone calls.
Yeah.
So just some KYC.
Yeah, and I think that the CFPB doesn't regulate this space, but they use a phrase in their regulations about on their exams when they are reviewing companies, they review them related to the size, scope, and complexity of the business, right?
Yeah.
And I think that that's super important to take into account, right? So like, you probably would not do. You would have a different level of diligence if you were Bank of America than you would John and Tammy's mortgage shop, right? And that's okay because you don't run the same risk, right?
Right.
Bank of America has higher risk. So that's one thing to think through as well is from a due diligence perspective, I'm not asking you to go draw their blood and make sure they say they are, but like you want to be able to do something that a reasonable person would come in and say, you took the appropriate steps to make sure that these people weren't going to violate the law.
Right. And, speaking of banking, I was an auditor for a bank at some point, and it's you trust, but you verify.
That's right.
Doesn't matter what the client gives you, it's still your due diligence to go out and verify the information that you've been provided and to keep your eye on it from at an ongoing basis.
Yeah, absolutely.
Okay, so you mentioned in your newsletter the 2015 FCC order that addressed who makes a call for TCPA purposes.
Yep.
Can you talk about that a little bit and some of the things that kind of turned for this?
Yeah, and I think it's where the case law stems from, right? Was that FCC order, and it's what is the FCC came in and said, look, it's a totality of the circumstances, it's contractual, it's actions, it's where are you on our spectrum that we've talked about this time, right? And when we think about that, that's where that stems from. Now, one thing that is interesting about that is we've all seen over the last 6 to 9 months a lot of changing in case law because of some Supreme Court decisions. Because that came from an FCC order, that could be challenged. That court would review it. Now, I don't think that it's going to go anywhere because this is, well, bluntly, vicarious liability and agency is not, the FCC didn't invent it, right? Like it's across all spectrum
Mm-hmm.
of common law, and agency principles have been in common law forever. So this is, I don't think you're going to be very successful in it. Someone may try it, good for you.
Right.
But it's one of those things that even if the court said, yeah, that FCC order, they shouldn't have done this order, but because of apparent authority or because of the actual authority this party had, you're still liable, right? So that is one thing I think we could see a challenge on. I would be very interested in that challenge. I would not make it, but I would be very interested in it. But
Right.
it's an interesting place to be at. So I think
I
that is something to think through. It's just like, there's been a lot of, talk about our calls text. I mean, excuse me, our text calls. Our do we need prior express written consent? We're still in a world where the vast majority of the country is following those rules that text or calls,
mm-hmm.
right? And
Mm-hmm.
we need prior express written consent for marketing. So I'm not having my clients change their practices just
No.
right. It's one of those things that it's a belt and suspenders approach, if you will. So that's kind of where my guidance has been.
Yeah, I wouldn't try to walk that back.
Yeah.
Those key regulations that we've all been following, I would not try to walk those back right now.
No.
Um, you have a case, what's the name of that case? Cunningham v. Montez,
Hmm.
which gives an example of how the dialer platform became the initiator.
Yep.
Can you talk about that case?
Yeah. So that was an interesting case. That it was a telemarketer. Defendant was a telemarketer, and uh, the court applied the totality of the circumstances, right? And looked at four different factors that the telemarketer at this point was uh, setting up the customer accounts. They're providing the technical assistance to set up the integrations. They had set it up to enable high call volume. And then in some cases, they were running the campaigns and they were loading the call list and they were hitting send, right? And the court said, those first three things, the setting up the accounts, providing the technical assistance, and letting the caller do high volume calling, probably not in and of itself enough to cross the line, but the running the campaigns and writing the scripts is going to push you over that potentially
The
push you over
marker.
that line of initiating the call, right?
Yeah.
Again, because without running the campaigns and writing the scripts, there are no calls, right? Um,
Hmm.
and now, of course, you could say that about all those four factors, right? Like, oh well, if they don't have an account, there's not a call. Okay, yeah, that's accurate, I guess. But that's what we mean by totality of the circumstances. You have to look at the whole thing, right?
Hmm.
Like how involved in the process is the platform, right? And the uh, there's a great quote from one of the cases, and I'll get it wrong, but it's something basically like, look, if you've set up a platform that people can go blatantly violate the TCPA, you don't get to say, well, they shouldn't have done that.
Right.
And because
Right.
so if they're using the system exactly as you've set it up to be used, right, and they're violating the TCPA because of how the system is set up, you're going to run into potential liability issues.
Hmm. Hmm. So let's give everyone some hope though.
Yeah.
We want to warn everyone, our audience, on where your liability should begin, where it should end. We're putting warnings out there, and we're doing that because we want this industry to be sustainable, and we want to show that we have people in this industry that are doing things correctly. or following the regulations, this can be done. A lot of the proposed rulemaking is aimed towards bad actors. It's not aimed towards us, those on this call, the ones who want to do things right. So there is a proper way to do this.
Yep.
And just John, can you give some practicals on things that we should do? I mean, I can give some from an auditing perspective. I'm big on auditing. Whatever you do, understand everything from beginning to end, what your telemarketer, what your platform, whatever position you're in, make sure you understand every process and have that documented for your own safekeeping. And
Yep.
every now and then just go in and audit and make sure things are still as they were from the beginning. Just keep your eye on things.
Yeah, and I think that from an auditing perspective, all of us know what normal looks like in our business, right? And I get, if running a lead generator, you get X number of leads from this guy, Y number of leads from this guy, Z number of leads from this guy. And if this guy who sends you X number of leads a day starts sending you 10X leads, right? What's happened? There is something happening here, especially if you didn't expect those. So that's you've got to pay attention to those anomalies.
Red flags. Yeah.
Yeah, those anomalies. Something has changed here that I wasn't ready for. Why has this changed? Right. So, but I would say practically, and I'm going to go back to something I said at the very beginning. The key word in vicarious liability is liability, right? And that means you have done something wrong. You are liable for TCPA violations. That means you didn't have the right consent, or you did something else, or you called somebody you weren't supposed to, you violated DNC regs, something like that. If you are running a good compliance program where you get consent before you call, you're following up on the revocations and you're taking those out. You're running an internal DNC. You've got a great policies and procedures, right? That you're following. This is a low risk area, right? Because you're doing everything you're supposed to be doing. The way to lower that risk even more is monitor your vendors, like you said, right? Like, do those audits. Are they doing what they said they're going to do? Are they doing what they're supposed to be doing? Which is an important thing, right? It is, if they're supposed to be calling people and they're not going to call more than 3 times a day, and all of a sudden you're getting complaints from consumers, you called me 6 times in one day. Like, you probably should look into that, right? I've worked at places that I've said in the past that customer complaints are the canary in the coal mine of what's going on in your business. And I can remember we got a lot of complaints one time because customers, this is a true story, weren't getting their Fortnite V-Bucks that they were supposed to be getting. And we went back and tracked those people down, and those ads were running on places they weren't supposed to be running, right? So you've got to look into that. You've got to do a good job on those third party management, like what these people are doing in your name. Because what they're doing in your name is putting you at risk. So again, if you're running a tight compliance program, that's great. Add that third party vendor management and bring that risk down even more.
Absolutely. This can be done.
Yeah, absolutely.
It's
absolutely. The other thing I would say is vendors, if you have a vendor who is telling you something that is too good to be true, it probably is. So that's just something else. Like, I've seen too much to think otherwise. Maybe I'm skeptical. Maybe I'm just an old cynic. Both of those things are true, but that doesn't mean I'm wrong.
Yeah. And don't forget to contractually too, make sure your contracts say you're both going to comply, you're both going to follow the rules and regulations, what you have a right to do, what you have a right not to do. So don't forget your contracting as well.
Yep, absolutely. Looks like we just got one more question.
All righty.
To what extent can an AI voice agent platform provider limit or eliminate liability by comprehensively defining usage restrictions, compliance obligations, and disclaimers within its terms of service or privacy policy. Well, those three things right there go a long, long way. So, a properly drafted terms of service and privacy policy goes a long way. Holding the platform users to compliance obligations, whether that be consent, whether that be messaging, acceptable use policies, those kind of things go a long way. And comprehensively defining usage restrictions, again, also goes a long way, right? So like, it's compliance, I like to say, is also like a Jenga tower, right? So you've got this big tower of blocks, and you can take one or two out, but there's some that if you take those out, like it's going to fall down, right? So what you're doing here is you're using those restrictions in your contractual terms and the practices and monitoring them that we're going to be doing in those platforms, right? To build that tower up and make it as secure as possible.
Mm-hmm. All right, let's get your newsletter link in the chat for people to grab. We'll put your LinkedIn on there, your website. Put those links up for people to grab to.
I think those are up there. So yeah, best place to find me is LinkedIn. I do have a newsletter on my website. You can go to henson-legal.com and sign up for that newsletter there. And then you can find me on LinkedIn. I'm John Henson. I look like this. That's where I'll be.
Yep. And you'll be at LeadsCon. So
I will be at LeadsCon. I'll be at LeadsCon. I'm speaking Thursday. And if you're there, please hit me up and we'd love to talk to you.
Yep. And I'll see you all at LeadsCon too. Any more questions? I think that's it.
Just got another one.
Okay, let's go.
From a consumer lender perspective, what's the optimal point within the loan origination life cycle to obtain prior express written consent under the TCPA? Specifically, should this authorization be captured strictly during the initial application phase, or are there other strategic touch points throughout the origination phase where it can be effectively and compliantly secured? I've worked at a lender before. I would say do it as early in the process as possible, because it minimizes risk down the whole thread. So if you can do it online, where they fill out a form, when you take the 1003, anytime you're going to get information from the consumer, it's pretty easy to get that add that consent language there and make sure you get that at the same time. I think it's just harder to get people. I mean, look, if you're a consumer lender, and Tammy, you know this too. Gosh, it would be great if they sent me documents that I asked for, but there's a lot of times that I have to pull teeth to get it, right? So if I can get it all up front when they're all happy and they want to click buttons and they want to sign documents, that's great. Because if I'm relying on it at the end of the process, it just becomes harder. Just practically. That's not a legal advice, that part, but like it's just practically, it's just harder to get that.
Right.
By the way, none of this has been legal advice. This has all been legal knowledge sharing. I'm not your attorney.
Right.
Contact me if you want me to be. I can be.
All right. I think that is it, John.
All right. Well, thank you, ma'am. I appreciate it. And thank you, everybody. These were some great questions. Again, feel free to hit me up and shoot me an email or LinkedIn message, and happy to connect and look forward to the next one, Tammy.
All right. Sounds good. Thank you, everyone. Bye-bye.